Yes, I can go.
Hi, well, welcome everyone. My name is Ben Spies. I'm a partner at Lady Bennett Blumstein, and I'm here with my associate Noah Starr. And this is the section meeting, the real estate section meeting of the Alaska Bar. And Noah and I are going to walk through 4 cases from 2024, which are real estate cases and or relevant to real estate. Just a disclaimer at the outset, this is not necessarily, in fact, I'm sure it is not all of the cases that the Alaska Supreme Court dealt with in 2024 applicable to real estate. There may be others which are more interesting and others which are more relevant. These are just the ones we grabbed and are going to talk about. We're going to try and keep this straightforward and accessible. And if folks have questions, drop the questions in the chat, and or it would in fact be better if you just went off mute and just interrupted and asked the questions. So with that, we will go to a screen share. Our PowerPoint is, we don't claim that it's accurate, correct, or intelligently presented, but we will look forward to the discussion. And again, please jump in and ask questions as you like. And these are the 4 cases we're going to do. Winco v. Huffman, which is a zoning case. Williams v. Strong, which is kind of a contract statute of limitations case with I think some timely application to real estate. Park v. Brown, which is a adverse possession case, and Joy v. Hahn, which is a
Purchase option case, and when the court will enforce it by specific performance.
Yeah. So with those exciting topics on our plate, let's get going with Winco v. Anchorage. This case is about who may challenge a zoning decision, when or when does an aggrieved party have standing to challenge a zoning decision. And I like this case because I think it establishes a really basic and important point, which is you do not have standing to challenge a zoning decisions if your only injury is if your only complaint is one of business competition. In other words, you can't challenge a zoning decision if you lost out in a business competition. It's a really basic point, but it's a good one and worth remembering. So here's the deal with this case. In 2019, the federal USGS was looking for a new location in Anchorage. They were seeking a new 20-year commercial lease, pretty attractive lease for a commercial landlord. So no surprise, there was some competition. One of the parties here was Huffman. Huffman had the previous 20-year lease with USGS, and Huffman wanted to continue. Winco showed up and said, no, we're going to offer the lease, and we have this great building in Midtown, and it's in the B3 zoning district. So Winco went to the municipal planning department, and they got a determination that USGS's use was consistent with the B3 district. So what we have here is a planning department determination, and that's sort of the substance of this. The planning department was asked to and made a decision on a zoning issue. The beneficiary of this decision, of course, was Winco, who won approval for USGS use in B3. Huffman lost out on its bid. It lost out on its 20-year lease, and it was mad. So, yeah. slide. So here we have Huffman, who lost out on a lease. They'd lost out on a 20-year lease. They'd lost a lot of money, and they were unhappy. Why were they unhappy? Because they think that the planning department made a bad decision. The B3 zoning district doesn't allow for warehouse use. And so what did they do? They appealed. Now, spoiler alert, the Alaska Supreme Court, this story ends with the Supreme Court saying, sorry, Huffman, you are not a person aggrieved here. You do not have the right to challenge a zoning board decision in state court, because the only thing you're complaining about is competition. And that's not, the purpose of zoning is not to protect people from competition. Next. So what happened here was, again, the planning department made a decision. They said, okay, this use is permitted in B3. Winco was happy. They got their terrific 20-year lease with the USGS. Huffman promptly appealed the planning department decision to the municipal zoning board. Okay, so let's pause for a second. This is an appeal of an administrative decision made by the muni. Who is the appeal made to? It's made to the zoning board. Okay, so the question here is, well, if Huffman's appealing to the zoning board, this is an administrative appeal to a municipal body, the zoning board. What standing do you need to have to complain to the zoning board? And the municipal standard is you just have to be a party in interest. This basically means here at bullet 2, anyone may appeal a decision of the planning department to the zoning board. And the Supreme Court has something interesting to say about this, notably that Anchorage is not setting the bar very high if you want to complain about a decision. They wrote, regardless of interest, coherence, or even relevance to the matter, the universe of persons who may appeal to the zoning board is virtually without boundary. And they noted, like, look, standing for municipal appeals is up to the municipality. Anchorage has set it broad. If anyone wants to complain about a zoning decision to the zoning board, they can go for it. And Huffman did that. And the zoning board upheld the decision of the planning department. The problem occurred at the next step. Huffman appealed to the zoning board. They were not successful. They said, oh yeah, we're going to appeal to state superior court, which throws them into a different arena under a different standing requirement. So if you go from the zoning board to superior court, no longer are you simply a person of interest. You need to be a person aggrieved. So the question is, if I want to complain about a zoning decision in state court, I need to be a person aggrieved.
Jesus,
What does that mean? Go ahead, Mark.
that parking lot is nasty. They could put some more gravel up.
So the Supreme Court had some interesting chatter here about standing. I think this case is really worth reading for that reason. It lays out some very basic standing stuff and just clarifies that, you know, state courts are not a catch-all for everyone who's unhappy. You know, you have to have a specific injury, and it's not a forum for generalized complaints. So they had, again, here's some more quotes from the Supreme Court about, you know, what standing you need to appeal a zoning decision in state court. And here's where they came to their point, which I think is the good takeaway from this case. A party's interest as a business competitor is not enough to be a person aggrieved. Just because you don't like a zoning decision which caused you to lose a bid for a lease, now that doesn't cut it to bring a complaint in state court. Nor can you stand there and say, well, you know, we have a general interest in upholding the zoning plan. That's not going to cut it either. And these are the two things that Huffman was fishing for to get standing in court. And the court wrote, the prevention of competition is not a proper element of zoning. It's not the function of zoning to provide protection for existing enterprises. So that's the takeaway. Let's go back one slide, sorry. So we're going to move quickly through these cases, but before leaving Winco, any thoughts, observations, questions? All right, I guess not. The USGS is snuggled nicely in Midtown zoning B3 for the next 20 years, and Huffman is out of luck. Next case. All right, this case is Williams v. Strong. The decision was in September of this year. This is sort of I'm not in love with this case. If you read it, it's got got some complicating nuance. And so for the purpose of what we're talking about here, I'm just going to focus on one thing, mostly because it's interesting to me. And the court here went straight to an issue that I frequently struggle with, which is statute of limitations for breaches of contract. And, when does the cause of action arise? When is it told? And I run into this question a lot. I frequently run into it in connection with commercial leases and other real estate type contracts. And I think the good, when I start thinking about this, the thing to remember here is that, real estate contracts of all stripes are subject to a 3-year statute of limitations. And that's true for commercial leases. What was going on here was a little confusing, but in a nutshell, you have Strong, who was a neighbor to Williams. Williams had a driveway which was apparently not well designed, and it resulted in flooding on Plaintiff Strong's property. Plaintiff Strong was mad about this, and he sued him way back, like in 2011 or 12. Related to that early lawsuit, they had a settlement agreement in March 2012, in which Williams agreed to do certain work to fix the driveway. That work was completed in June 2012, and the parties went on their merry way. A year later, in July 2013, Strong, the plaintiff, noticed that there was further damage resulting from the driveway. And at that time, that's when the damages accrued in March 2013. So we get into some complicated back and forth here about timeframes and who knew what when. But the takeaway, I think, here is that the cause of action accrues. This is not a new point, but the Supreme Court underlined it, which is the cause of action accrues at the time the plaintiff knows of all the relevant facts, or should have known, was on inquiry notice. Let's go to the next slide. Actually, excuse me, go back one second. So to lay out some of the facts here, and I hope this isn't too confusing. Again, the contract was in March 2012. The performance under the contract, i.e. the work to be done, was done in June 2012. Strong's grandson showed up at court and he said, oh yeah, in June 2012, when the work was going on, he told his grandfather, the plaintiff, that there were problems with the construction. The plaintiff, Strong, responded again in June 2012, yeah, I know about the problems, and he was going to get after it to do it. Again, June 2012. In July 2015, more than 3 years later, he filed suit. So the Supreme Court, again, ruled that the claim accrued at the time that Strong, the plaintiff, knew of the breach, which was in June 2012. And the statute of limitations was not told. Let's go to the next slide. Here's Alaska statute 09.10.053 that sets up that this is the statute of limitations for contracts, including contracts related to real estate and leases. The general rule is claim must be brought within 3 years. And this means that the cause of action accrues and the statute begins to run at the time of breach. And next point, and this is an important one, the cause of action does not begin to run at the time the damages are sustained as a result of the breach. It's at the time of breach. The question that I frequently run into, and I'm always getting confused about, is what happens if you don't know about it? What happens if I'm a tenant under a lease and I'm unaware of a landlord breach? Or vice versa, I'm a landlord. Or under any contract. This is the discovery rule. The statute doesn't begin to run until the party discovers the existence of the essential elements to the cause of action. That's the notice date. Or they should know of the cause of action and should begin an inquiry into the facts. That's the inquiry notice date. So the relevant inquiry when you're dealing with this murky set of issues is what's the date the claimant knew or should have known of the facts supporting the cause of action. Always murky. So what the court said here is, look, Strong, you knew about this breach in June 2012. Your grandson told you, and you affirmed that you knew that there was a problem here, and you said affirmatively you were going to get after it. And so at minimum, Plaintiff Strong was on inquiry notice at the time of the construction in June 2012. Now, the damages didn't appear for a year later until July 2013. And the Superior Court said, oh, well, the cause of action didn't begin until July or June 2013. And the Supreme Court's point was, no, that's not right. The cause of action doesn't begin when the damages emerge. The cause of action begins when the plaintiff knew or should have known about it. So poor Plaintiff Strong here, he filed, I've got the date wrong there in the slide. He filed in July 21, 2015, and the court says, you are 22 days late, my friend. Your claims are barred. So I want to go to one more question on this. What's the application to real estate leasing? This is actually why I'm interested in this case. I want to shift to another case that if folks haven't read, you might be interested in, which is Griffith v. Hemphill, and I'll send this around after this meeting. This is a good case that's worth reading if you deal with commercial leases, and it deals squarely with this issue of breaches under a lease and the statute of limitations. And the case that we were just talking about, the court takes what seems to be kind of a harsh approach, like, look, your cause of action accrues when you know about the breach, okay? This case here is interesting in light of that. In this case, it's a commercial lease where the landlord had the obligation to fix the roof, general landlord obligation to maintain the premises, right? Typical leasing arrangement. And as far back as 2010, the tenant started complaining that the landlord wasn't fixing the roof. And finally, after a series of events around the roof, leaking, collapse, blah, 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 the tenant filed suit in 2019. The landlord instantly came back and said, sorry, you guys are barred by the 3-year statute of limitations because you were aware of my breach in 2010, right? That seems pretty clear. But the Supreme Court, I think, refreshingly and correctly came back and said, well, yeah, that's true. I mean, there was a breach in 2010, but the landlord's duty to maintain the real estate is an ongoing duty. And so every breach is a separate claim. Each separate claim has a separate 3-year statute of limitations. And so while the breach from 2010 may have been time barred, every winter when it leaked, or every separate event around the roof was a separate claim with its own 3-year statute of limitations. So, my takeaway from all this is that statute of limitations questions remain super complicated and annoying. I'm dealing with one right now with a tenant who's very concerned about being badly overcharged for CAMs. And I think the correct posture is, look, every time we're overcharged for CAMs, it's a new breach. And even though the tenant may have known about being overcharged, extending back 10 years, every time that they do overcharge is a fresh cause of action. But these remain statute of limitations remain difficult questions, particularly in leases, I think. So Griffith v. Hemphill is a good case. Questions or observations on Strong v. Williams, Griffith v. Hemphill, or statutes of limitation?
Okay. Yeah, Ben, this is Sarah Gilstrom. I had one question on that lease. Was that a different lease every year, or was it one continuous, like, long-term lease?
Yeah, good question. I should have been clear about that. That was one long-term lease.
Okay, wow.
So think about it this way, like let's say they sign a 20-year lease in 2010. Okay, landlord doesn't perform in year 1. The roof is leaking, right? In 2010, landlord non-performance. 2011, there's the roof leaks again, or there's a fresh issue with the roof. And let's assume there's a fresh issue every year for each of the 20 years of the lease. Each event of non-performance or breach is a fresh claim or cause of action.
Oh, Ben?
Yeah.
This is Steve Shamburek. I had a question. I've seen this situation come up, and what the court does is only allows for the breaches within the 3-year period. So it's not a way of renewing the cause of action and taking it back beyond 3 years.
Yeah, that's correct, Steve, and I should have clarified that. This is not a silver bullet to go all the way back, in this case, to 2010. They brought the landlord's defense, they filed in 2019, and they sought damages for a 2016 breach. And the landlord's answer was, no, sorry guys, you've known about these roof problems since 2010. Yeah, sure, I, landlord, haven't done anything about it, but you can't complain about my 2016 conduct because I was non-performing as back as 2010. Which is sort of a weird argument. Like, I've been horribly bad in performing under this lease and you've known about it. So the court said, and Steve, thank you for clarifying this, the court didn't revive the 2010 claims. The point I'm making is, even though they knew that the landlord was not performing and fixing the roof, each failure of performance was a fresh cause of action. So the court said, look, even though the tenant knew about this going back to 2010, the 2016 damage or failure to maintain in 2016 is it's a cause of action. Does that make sense, Steve? All right. So don't despair if you've known about something for a long time. If there's a recurring obligation to perform, you may still have a case. So let's keep going, and Noah's going to take it from here with a pretty interesting case about adverse possession, which is everyone's favorite topic. So go ahead.
Hi, everybody. I'll take it from here and take this first case, Park versus Brown, which the opinion came out in June of this year. And it's kind of a good adverse possession chestnut in that it goes through the elements as we've all known them since law school, but it, I think, has an interesting set of facts and certainly moves the law in a direction that is of relevance to this group. So I'm gonna lay out some of the facts, and don't worry, there's a visual illustration of the adverse possession that will follow this written description of the facts, and then we'll kind of proceed into the two major issues standing in this case. So Janice Park had a residential lot in South Anchorage. Her neighbors, Karen and Bradley Brown, owned the adjacent vacant lot. They shared a north-south boundary, and there is a fence on in part on the boundary line, in part not on the boundary line. That was installed before either park or the neighbors had acquired their ownership of their respective lots. But doesn't follow the platted property line strictly. The fence technically added a thin strip of the neighbor's vacant land to Park's residential property. And Park and her husband had purchased the lot Park and her ex-husband purchased and owned the lot since 2005. When in 2016, the neighbors surveyed the two lots, they discovered that the fence was in fact intruding into their lot, and they took action to try and quiet title and reset the functional boundary line, so to speak. And they sued Park both to quiet title and for trespass. And Park responded that she had acquired title by adverse possession. So for the Superior Court, that's the posture: one claim for quiet title and trespass, and then an affirmative defense for adverse possession. The Superior Court, in fact, found that there had not been adverse possession, but on appeal to Alaska Supreme Court, the court reversed. So here's just the diagram that actually appears in the opinion as well. And so you can see the thick bolded line going on to lot 1. That's where the fence is, and then there's an extrapolated line out from that I think shows like a right angle triangle of how lot 2, Park's lot, grew in size through the fence, and the extrapolated line from there. And is that a question? Okay, I'll keep going. And I'll sort of get into how Park used the lot as we go through the elements of adverse possession that the Supreme Court analyzed. And so putting these up here just sort of to anchor the presentation and any questions or discussion to come, adverse possession and its elements are defined by statute. The first element is continuous possession of the land for a period defined by statute. You can claim adverse possession either because of a good faith but mistaken belief that the property lies within your property's boundaries. But when you do that, you have to demonstrate that the elements of adverse possession existed for a continuous period of 10 years. And then this is language from the court in this exact decision, and it sort of previews where they're going, but this is the rule paragraph, if you will, of adverse possession. They say this 10-year period may be satisfied by successive adverse possessors who may tack their periods of possession together if privity exists between them. So that's element number 1. Element number 2 is that the continuous possession must be open and notorious. And then element number 3, it must be exclusive and hostile to the record owner. And so to prevail on the affirmative defense or to acquire title under a claim for adverse possession, if one was the plaintiff, you must prove each of those elements by clear and convincing evidence. So issue number 1, raised by Park as appellant, was her possession continuous? And the Alaska Supreme Court said yes through tacking. So if you remember, Park and her ex-husband had purchased
this is the webinar, then I'm gonna go to this other thing. All right. Oh, okay.
And I think it was in 2007, there was a period of time in which the Superior Court, administering Park and her ex-husband's divorce, ordered that their property be in her husband's name, not her name, that was in 2008. But by the resolution of the divorce, the property returned to Park in her name. So relevant here, the Browns were saying, hey, she has not possessed the property for a continuous period of 10 years, so she can't assert adverse possession as an affirmative defense. The Supreme Court disagreed, and it held that the doctrine of tacking allows a property owner to claim title by adverse possession when you can tack a period of possession to a predecessor in interest, even if neither possessor on their own occupied the property for a full 10 years. And then this quote on the bottom is sort of, I think, the key takeaway from this case, and I'll quickly run through it. At all times during the relevant period, either Park or Husseini, that's Park's ex-husband, held possession and title adverse to the Browns, with no break in the adverse possession as against the Browns. At no point did the Browns enter the disputed property or otherwise attempt to assert their title. The dispossession of the true owner continued uninterrupted. Park testified that both she and Husseini understood their property to encompass the areas at issue in this case, and the clerk's deed is sufficient to establish privity. That is all that is required for the doctrine of tacking to apply under the circumstances of this case. So the takeaway as to this issue is that if the successors in interest are in privity, or rather, if the successor to the previous interest holder is in privity to that interest holder, they can tack to get to the 10-year period to satisfy the elements of adverse possession in Title IX. I do want to highlight the language used here where the Supreme Court said that the dispossession of the true owner continued uninterrupted, because that will come up in the second issue, or I guess sort of a sub-issue in this tacking question, because Brown's additional argument for why, sort of an if-then argument, or an even-if argument more accurately, Brown's first point on appeal was no tacking, or rather no continuous possession. Next argument was, sure, maybe Park and her ex-husband were in privity, but the legislature actually cabined what counts as uninterrupted possession for the purposes of adverse possession, and that was by legislative amendment in 2003, and so this kind of tacking was abrogated or derogated by the legislature and is no longer permissible to establish this element of adverse possession. The Supreme Court rejected this argument and did sort of fairly short, but I think effectively comprehensive, I should say, analysis of the 2003 amendments to AS 09-45052, the adverse possession statute. And so Brown's argument really turned on the presence of the word uninterrupted in the continuous possession language, and the court rejected that meant anything as applied to this case. They thought that the 2003 amendments were meant to limit the legal rights of bad faith squatters, so people who were trying to basically get property without any real claim to it, just showing up and knowing it's not theirs and squatting and trying to run out the clock. But the amendments did not modify adverse possession as applied to boundary dispute cases like this one. And then, quote, this is what they said, the legislature sought to narrow the application of adverse possession to circumstances where adverse possession served a, quote, continuing social utility, such as, quote, cleaning up the fence that got built 2 feet on the wrong side of the property line. And some of that is quotes from legislative history. It's a quote in whole from this case, and it more or less describes the exact facts of this case, which I think is why this analysis is both short but comprehensive in rejecting Brown's argument for why adverse possession shouldn't apply here. And I think that the reason why the uninterrupted language is important is that though this is a real estate case, there's also a little bit of an element of statutory interpretation questions, and there's a presumption against interpreting statutes language to derogate or abrogate common law. And since tacking is a common law right to adverse possessors that predates the existence of AS 09-45052 and comes from that lineage, the Supreme Court was not going to overrule how it thought tacking should apply in this case at common law because of the word uninterrupted in the phrase of uninterrupted continuous possession. So that's how they resolved that issue. And I could stop there just to see if there's any questions before I proceed to the second issue in the case.
Any thoughts or comments on this rich legal ground that everyone loves to argue about? Jim McCollum?
Well, I can.
No,
keep going and I'll pause again at the end of issue 2. Which is actually a much shorter issue. So the next question was that Park appealed on and the Browns disputed as appellees, was whether Park's possession of that extrapolated line and fenced area was hostile. And so again, the Supreme Court, I think in presenting the rule statement here, kind of previewed where they were going to go and applying the rule to the facts. They talked about how hostile use under the statute is really a circumstantial question. It depends on the type of land in question. So, you know, a vacant lot bordering a residential lot requires a different kind of hostile use than maybe 2 vacant lots, or, you know, pick your real estate hypothetical. But the core purpose in evaluating the circumstances of hostile use is the adverse possessor has to put the record owner on notice of the existence of their adverse claim. And so I'm gonna just really fast forward back to our little diagram, just to remind us what we're talking about. So it looks like it says here that we've got 177 feet is the area between lots 1 and 2. Although if I'm reading this correctly, it might be 177 in total, and then 85 feet is the area from the A to B point, which is where the fence actually ran.
That's right.
But altogether, we're talking about 177 feet in this sort of right triangle of dispute. And Park did stuff on the land, and Brown's main argument was like, there's a presumption of permitted use, and we permitted this activity, so it wasn't hostile to us. Court said, no way. We're not gonna find no adverse possession merely on the presumption of permitted use, because this kind of use is not typical permitted use between 2 neighbors. Park maintained and improved the land in common with her own property, cleared brush, parked cars, and a fact that the Supreme Court, I think unintentionally, comedically, continue to refer to, is that she had planted a choke cherries tree early on in her tenure on the property. Remember, they bought this in 2005 and the litigation started in 2016 along the extrapolated property line, and actually the choke cherry tree grew to the point that it could support a tree swing, which was also installed for use by Park and residents of her property. And so the Supreme Court said, and this is where I think they were maybe unintentionally comedic, although I guess not very funny for the Browns, quote, "We cannot say planting a tree that has grown to the height of 20 feet is a reasonable neighborly use of adjacent property." And that was paired with a fairly definitive statement about how the presumption of permissive use does not apply to that kind of activity. So really, it came down to this fact-intensive exercise of how was the adverse claimant using the property? Is it something that could reasonably be considered neighborly, i.e., you know, if I took my neighbor's trash out or I put my trash on my neighbor's property technically for 10 years, maybe that's more normal and that's presumed to be permitted, not hostile. But we now know that if you plant a choke cherry tree or presumably any other tree that grows to the height of 20 feet, that kind of looks hostile. And is that a question?
Yeah, I got a question for Noah, because he took on the burden of analyzing this case, not me, and wanted to ask. So the Browns maintained that no, this is not adverse possession because we gave you permission. Did they present any evidence of that? I mean, did they have an email, or did they have a text message or anything at all other than, gee, of course it was permissive even though no one ever communicated it or talked about it?
So my understanding, and I'm gonna confirm exactly what they did, is that on appeal, the Browns raised the presumption of permissive use and argued Park has not rebutted this presumption. So that presumption sort of exists regardless of whether express permission was obtained. But as the Supreme Court said, following a recitation of the Browns argument, they said, quote, "But there was no evidence that Park ever sought or received the Browns' permission to use the extrapolated area, and Park has shown that, quote, she at all times acted as if the land were hers and treated it as hers." And then they kind of listed the types of activities in rebutting the application of the presumption that I just gestured towards. Quote, "While a landowner may welcome a neighbor mowing part of his lawn or clearing away untidy brush, and the occasional parked car may reflect a neighborly courtesy, quote, we cannot say planting a tree that has grown to the height of 20 feet is a reasonable neighborly use of adjacent property." So in other words, you could imagine different facts, or say Park had maybe for 10 years, only, you know, on occasion parked an extra car in the extrapolated area. And defendants against adverse possession can rely on the presumption in that kind of case. If they say, well, look, we allowed it for 10 years because we were just being nice. We weren't relinquishing our property, right? We just wanted to be neighborly. That's when the presumption tends to apply. But here, the Supreme Court established a fact-based sort of outer limit to that, which is, well, no, you can't come in without evidence of permission and argue for the presumption against clearly non-neighborly activity.
Got it. That's good.
So I think that concludes everything I was going to talk about for this case. Any other questions from the group?
Real
Hello?
question from me. This is Will Wright. I take it they didn't, but did anyone argue boundary by acquiescence in this matter?
Oh, some sailing from my eye. Now there's some. What's it called?
You, the other person will. I do not believe that anyone argued boundary by acquiescence, but I have the case in front of me.
All right.
What is boundary by acquiescence?
Well, the Supreme Court recognized it about a decade ago in Lee versus Conrad. Yeah, it just the facts are very similar here. There was kind of this extrapolated line out from a fence, and they said, you know, we're gonna just say that, you know, that this equitable doctrine applies even if adverse possession isn't available. And it's a 2014 case where they did it. Yeah, I think it requires, you know, some reasonable marked line. I think mutual recognition of this line and period of time. I don't remember the precise period, but yeah, it
So
just seemed very factually analogous to that case.
So does boundary by acquiescence, that doesn't result in adverse possession? It sounds like boundary by acquiescence might result in a easement, right? Or what?
Well, I believe it's just title. Is
Okay.
my
What's that
understanding
case?
of the document. It's Lee
What's
versus
that case?
Lee versus Conrad, and it's 337 P third 510. I'm just pulling it up now. It's one I often go to for various things. Covers a lot of different ground.
Interesting.
Ben, I think it just creates a boundary line. It doesn't actually establish title to the property. I've seen the document before.
Okay.
So it establishes a boundary line, and so it creates like an easement right to use. Something like that,
And it's
maybe.
kind of like it. They create a common boundary. That's it. They don't establish the right, anything else other than that.
Interesting. Okay.
Yeah, I think, and I just confirmed that wasn't inserted here, and I'm generally familiar with Lee versus Conrad, but I think the difference here probably lies in the posture of the case, and that, so the vacant lot owners, if you remember the Browns, they do this survey in 16 and find out that basically that, well, in their eyes, Park was trespassing, and so they bring the claim, and she asserts it as an affirmative defense, which I think maybe explains why it, you know, she was sort of, I mean, from Park's perspective, I imagine it was better to go for all or nothing. The boundary line by acquiescence might not have insulated her from trespass liability in the same way, although I guess maybe it could have, but
I think it did. I think in Lee versus Conrad, that's why it was brought up, is that the neighbor who did a later survey said, hey, wait a second, this is my property, and brought trespass claims. So
well then, yeah, that's something to, I'd be curious to figure out why we reached a different result here than there, but I appreciate that.
yeah. Thanks. Sorry, I apparently need to
No, not at all.
this
No,
one.
that's helpful.
That's really interesting, Will. Thanks for citing that case. That's Levy Conrad, Alaska, 2014, boundary by acquiescence.
And I will say that in response to Will's question, he reminded me of two other points I wanted to make, that I should make rather, is one, they do talk about prescriptive easement, which the Superior Court on this open and hostile use question suggested that Park's use was not open and hostile based on a case called Tanala Limited versus Fowler, where the Supreme Court concluded that a claimant's use of land as an unimproved driveway and occasional storage area was insufficient to establish exclusive possession because it didn't put the record owners on notice. Instead, they said that the user had a prescriptive easement to do the same. But here, the Supreme Court sort of returned to the quality or the character of the use, pointing out, again, she maintained and improved the land, mowed the area, cleared brush, parked cars, and quote, most notably, planted a chokecherry tree in the area along the extrapolated property line. And in concluding the discussion of hostility, they referenced a couple of cases from other jurisdictions that involved adverse possession of vacant land. And so I think that's kind of where the fact-intensive nature of the hostility inquiry cut both ways. They both looked at how did the adverse possessor use the property, but also what was the nature of the land used by the person against whom adverse possession was asserted. And a couple of cases, including one from Washington, said that when you do things like clearing and mowing land for parking, garbage disposal, gardening and picnicking, and particularly when one side, the adverse possessor, has cleared and maintained property borders against a vacant lot, they find that all that activity, all that use was hostile. Well, I'm glad we had a good conversation about that case, because I think similar to Ben's second case, Joy v. Hahn is interesting, but I think maybe a little bit less rich for the purposes of discussion, though it does have some important takeaways for this group's purposes. So just very briefly on the facts, we have a 2017 lease agreement between Austin and Regina Joy, and a businessman named Randy Hahn. Randy was leasing the Joy's property for 3 years. Randy intended to use the property as the location for his firewood splitting business, which is called Best Split Firewood, which I abbreviate as BSF, a few other points in the slides here and to come. It's a pretty short 3-page lease, 3-year lease. It's actually a 1-page 3-year lease. And in that 1-page lease, there was a purchase option that allowed for Randy to purchase the property for an owner finance price of $1,295,000 with an $100K down payment. On that 1 page, it also included terms of the owner financing, which would be 20 years at an interest rate of 6%, and there was also an amortization schedule. So, in setting up the case, I think it's fair to say that the contract contained an express purchase option, but it had limited terms. And that's kind of where this dispute falls. Of additional relevance is who signed the agreement and for whom. Austin Joy and Regina Joy were listed as the owners, and Randy Hahn, followed by an underlined blank space, followed by the words herein called the occupant. Those were the signature blocks. Hahn wrote the words Best Split Firewood into the underlined blank space, basically indicating that his business would be the occupant of the leased property. Austin and Randy signed the agreement, so we had lessor lessee, but Regina did not sign it. She wasn't present. And so this case really turns on whether or not the option is enforceable. And it involved the Supreme Court applying a case that is about when the Supreme Court or any court in Alaska can enforce a contract where terms are missing or requiring additional interpretation. And the case there is called Rigo versus Decker, for those who might be familiar in the real estate and other contexts, excuse me. I guess a few additional facts to get to how the option became troublesome. Randy used the property as he said he would in the lease for his firewood business. He purchased a separate adjacent lot to store logs for use in that business. And then in 2020, at the end of his 3 years, he notified Austin and Regina that he intended to exercise the purchase option and deposited $100K in a trust account. Implied in all this is a bit of a dispute about who Randy was acting on behalf of. In wanting to purchase the lot, he did so as Best Split Firewood, or BSF. And that became another point of contention between him and the Joys. The Joys refused to sell under the option, arguing that the purchase option was not enforceable because Regina had not consented to the agreement. And also because,
Excellent.
no, it's, and also because there was this dispute about whether BSF could leverage the option, because Randy was the like named signatory to the contract. The Superior Court enforced the option and ordered specific performance, again applying Rigo v. Decker, directing the Joys to sell to Randy, and the Supreme Court affirmed. So, in applying Rigo versus Decker, the Supreme Court said that there was enough in the contract for the court to enforce the option and order specific performance. That inquiry under Rigo basically asks what's in the agreement and does it contain all the essential terms of an option to purchase commercial real estate. The Supreme Court said yes, it did. The lease agreement, even though it was on page, clearly identified the property, stated the terms that were being agreed upon, rather than something like these terms will be negotiated at a later time. And it articulated the central terms of the purchase, the total price, the down payment amount, the interest rate, and an amortization schedule. Nothing more was required to form an enforceable option in the written contract. And in addition to arguing that the contract was unenforceable because Regina didn't sign it, which both the Superior and Supreme Courts rejected, the Joyce kind of pointed to other cases saying, but hey, this is actually like this case, not Rigo. And the court distinguished those cases because they had fewer terms in the written contract. So Alaska Fur was a case where specific performance was not ordered on an option because there was neither a purchase price nor the method of determining a purchase price in the contract. And then in a case called Thrift Shop, the intent to enter into an agreement to purchase the property that was being leased was only stated orally, it wasn't actually in the written contract. Because here the court didn't have to do nearly as much as in those cases to interpret the terms, to enforce the option, it was okay to order specific performance. Those cases required a more active rewriting or supplying of terms beyond the intent of the parties as demonstrated in the written contract, and that's why the court wouldn't order specific performance or wouldn't enforce the contract provision for an option in those cases. And then, as I kind of previewed but didn't highlight in a slide because it's not as real estate focused, the court also very briefly discussed why it was okay for Randy to assign the contract to his business, or to assign the option right at the contract to his business Best Split Firewood, and the court basically said there's no limitation on assignment in the contract, and there's no reason to think that he couldn't assign it to his business. He had indicated the business would be occupying the property, and we think this is okay and good. So that's all I have on Joy v. Hahn. So happy to take questions about this case or the other, or anything else that folks would like to discuss.
Anything on Joy v. Hahn? I thought it was a nice in that it crystallized, what it takes to create an enforceable agreement, the ability to determine the purchase price and the other purchase terms. But thoughts or comments on that one? Hearing none, I would just add that, again, these four cases are ones that we thought were interesting. We're not saying that these are the only four real estate cases out there this year, but fascinating and rich stuff. Any feedback to me or Noah is welcome, and look forward to seeing you all again soon. We're going to have Steve Schimburek and I have been communicating, and I think we've got another real estate section meeting scheduled for January 28th of next year. And Steve and I are always looking for good topics. So if someone's got something they want to talk about, or if somebody wants to present, here is your opportunity. Let us know what you're interested in, and we would welcome people who would like to present at the next meeting or any others in the future.
Ben, just one thought I have is that if you just take a look at the 21 people who are here, there's at least maybe 200 years worth of legal experience And I've wondered sometimes if it wouldn't be desirable just to have a wide open roundtable discussion, maybe some direction on a couple topics, but I don't know. It's a different way to approach it.
For sure, there's a lot of that would be fun and interesting, and there's definitely a lot of combined experience here, so we can talk about that as an option. All right, well, it's Thursday afternoon at 12:57 p.m. and we're gonna sign off and look forward to being in touch and hearing from all of you, and at minimum seeing you. I believe that next date is January 28th, 2025. So
Thanks all,
and we'll see you next time.
Yeah, thank you.
Thank
Thank you.